Okay, after reading through the laws pertaining to dyslexia, and I wouldn't call them laws, it'd be regulatory guidance, some of this stuff, okay? Most of this stuff came out of with regards to dyslexia in Alabama, because this question came out of Alabama. The regulations or the policy, more like policy, came out of the State Department Board of Education, or the Alabama State Board of Education, or yeah, didn't come out of the legislature, didn't come from the feds, so it's a different, okay, and so that's what you sort of need to understand first and foremost, is that law in this country, we got law, we have regulations, we have state law, we just have different tiers. And so you got to be real careful. I mean, I think that we all just sort of use the word law as a catch-all, which is fine, but just understand for the purposes of this question, you got to be real careful, which is the answer I'm giving you. So I guess that's what I'm trying to get to, is that this is your answer. Is that with regards to the policies that have been put in place by the State Board of Education on dyslexia, they tucked it within the response intervention section. It's not within the regulations governing special education, and they are not included in the 504, which is a federal act, okay? So it exists over here, and it is part of the response intervention, sort of, but it was policy created by the State Board of Education. So therefore, we answer that next question. Is each child with a dyslexia diagnosis entitled to dyslexic specific intervention in school? Well, what does entitled mean? Because your entitlement under a state board policy where there's no enforcement provision given to the parent, then they can entitle your child all day long, but if you don't have any enforcement ability as a parent, then that entitlement really doesn't mean anything, does it? Now, that's different. If your child has a 504, the parent does have enforcement provisions in the form of being able to file a 504 complaint, an Office of Civil Rights complaint, and quite frankly, you still could with a 504 plan. But let's just say your child has a diagnosis, but not a 504 and not an IEP. Well, then your child exists outside of those protections. And yes, or under this policy, they could be receiving and then even make the parents feel like they're entitled to this type of intervention. But unless there's some kind of an enforcement mechanism for the parent, it's sort of a hollow policy. It's the same thing with Alabama's seclusion and restraint policy, because it says what the school can do and what they can't do, but there's no enforcement provision when the schools aren't doing it. There's nothing to hold anybody accountable for not doing it, even though it says that they can't use this position. Everybody's got to be trained. They've got to provide parent paperwork. They should never seclude. But where's the punishment? And there isn't any, which means that you might as well just throw that policy in the trash, because it was the same State Board of Education that created the provisions for this type of intervention. Now, under 504 or IEP, under an IEP, it is different, because now it's attached to a federal act and federal regulations established by Congress, which then empowered the parents as an equal participant in the planning for their child. That's under the IEP, which then you can sit there and, the school's responsible to provide your child a free and appropriate public education. And there would be a mechanism to enforce the entitlement to dyslexic specific intervention, or what I would call it more correctly stated, specific learning disability interventions based upon the peer-reviewed scientifically approach known for your child's individually recognized deficits, which that's where the dyslexia would come in, because the dyslexia would fall underneath that umbrella of the specific learning disability. I know that that sounds complicated, but you just sit there and you gotta understand how to navigate that this policy is not necessarily on the same level as these other protections. Even though the child may have the exact same type of interventions, but this child, because they don't have the protections, the parent can't necessarily enforce that entitlement. It ends up sort of acting or being looked at as sort of a false entitlement. Now, if the school is following through with it, great. But if they're not, I mean, that's what I'm telling you. You know, where's the mechanism for the parent just under a state board policy to be able to enforce it?